Thank you, Madison. Tom, there were like over 300 kids in the last group.
Oh, great.
Yeah, it's fascinating to see like how they come in.
Well, that's great news. I think we drilled down largely in the right spots. I agree. Maybe a little bit extra on the back end, a little less up front, but
I thought it was good, and I also think it was perfect for the age group. They need that foundation a little bit more because they haven't been exposed to it yet. So I actually like weighting the back end a little bit more and less of the front end. And this group, because the students are high school, the current event end and the more the court cases too. So I think it balances nicely. And then if you watch both of them, you're, basically 5th grade through college. You're good to go.
Yes, exactly. All in 30, 35 minutes, but yes.
Yeah, all jammed in. That is like my favorite. Okay, you have 1 minute to explain this giant court case stuff.
It's a good, it's actually very helpful. You have to be able to get to the essentials.
Exactly. Instead of, I love Nick, he just tries to talk faster. He's like, I'll get it in, Kerry. I'm like, okay.
He has the curse of an extraordinary amount of knowledge.
I'm still laughing at me teasing him in that email. I'm like, who uses those words? 2 more minutes, everybody. We will get started on an amazing topic of voting rights in America. I will say the weird thing about Zoom right now is that it won't let you, like the screen, the bar that lets me control things, it keeps hiding and not popping back up.
Oh.
So when I hesitate oddly, that's because it won't appear. Okay, guys, 1 more minute, we'll get started. Making sure my control is there. They did take away the power for me to write with a Sharpie on slides, which I'm a little sad about. But I remember I crossed out the wrong part of the Constitution once, and Jeff was like, no. I'm like, okay, it's coming back, it's coming back.
Yeah, I would think Jeff with crossing out the Constitution.
Right. I meant to underline it, and it looked like I crossed it out. I was like, okay, I'm not that good at this. So maybe that's why they stopped giving privileges. Hello, Margaret from West Palm Beach, Florida. Nice to see you in the house. We're going to start in 1 minute, and let's begin with the official recording. So welcome, everybody. Let us know where you're coming from in the chat. We are so excited to see you all come in. My name is Kerry Sautner. I'm Chief Learning Officer at the National Constitution Center today, and I'll be here to guide us through voting rights in America. And I'm really lucky today because I get our top scholar, Tom Donnelly. So Tom, would you like to introduce yourself?
Absolutely, Kerry. Hi, I'm Tom Donnelly. I am the Senior Fellow for Constitutional Studies at the National Constitution Center. So thanks so much for being with us. Can't wait to dig into this topic.
And it is a fun topic. And let's talk about what a hot topic it is. This is a great kind of like guiding line from Truman that we love. A vote is the best way of getting the kind of country and the kind of world you want. And the reason we start off with this is we want to look at this quote and say, who can vote and when can they vote over time? And where is voting in the Constitution? So we have people from Florida, from New Jersey, from California, from Pennsylvania. And all of that's going to come into play as we talk about how your state says that you can and can't vote from 1777 to today. So Tom's line in the last class, which I loved, and I'll just share it again. We're going to talk about voting from the colonial period and the Declaration of Independence all the way to COVID. So I hope you ate your Wheaties and we're going to get ready to go. Here are some guiding questions. Number 1, what does the original Constitution say about voting? How do constitutional amendments transform the Constitution and its relationship to voting? And what are the relative roles of the national government and the state governments in this context? Now, one thing I'm going to drop in the chat real quick is that second link is a worksheet. If you want to download that real quick and take notes on it, or just follow along with us, it's there if you love worksheets and tools like that. But Tom, let's get going. I'm going to give you the Constitution. Where do you want to start? There's a lot in there.
Oh boy, so yeah, just looking at the screen itself, it's a little daunting. But let's, as we always do, we'll begin with the text of the Constitution, and let's begin with the original Constitution, what we call the structural Constitution. And so you see here we have some provisions from Article 1 and one from Article 2. Let's just quickly walk through them and try to get a foundation in the founder's vision when it comes to voting and elections. So let's just kick right up. Let's go right to Article 1, Section 2. So as a reminder, the Constitution in Article 1 separates the legislative power of the national government between a U.S. House of Representatives and a U.S. Senate. So it splits it in two. In Article 1, Section 2 goes to the power, sort of the structure of the U.S. House of Representatives. And so it tells us who is going to vote for members of the House. And so what's the organizing principle here for the U.S. House of Representatives? Well, it's that old principle that we've talked about many times of popular sovereignty, ruled by we the people. And so what happens here is that Article 1, Section 2 says that the American people will vote directly for members of the U.S. House of Representatives. And what is going to be the main rule? What's going to be the foundation here of who's going to vote? Well, we're going to use the rules that each state has for its lower house. So we're going to use whatever rule a state has for its most democratic part of its government. That's what's going to apply to the U.S. House of Representatives. And so that's rooting, again, the U.S. House in that principle of popular sovereignty. So Article 1, Section 3 then gives us the U.S. Senate. And so we see a different organizing principle there. Whereas the U.S. House is rooted in popular sovereignty, the Senate is based on the principle of equal representation of the states. And so here, remember, every state gets 2 senators. Whether you're as big as New York or as small as Rhode Island, you get 2 senators. And so it's equal representation of the states. Who's going to select the U.S. senators? Well, it's going to be the state legislatures of each state. So it's equal representation of the states, but then it's also the state legislature selecting the members of the U.S. Senate. And so within then the original Constitution, we're rooting the U.S. House in the voice of we the people, and the voice of the U.S. Senate in the voice of we the states. The Senate becomes a key body in the framers' original vision of federalism. And so those are the 2 houses of Congress. Well, of course, and as we get into the amendments, we'll see that we actually alter how we select U.S. senators. So today with the 17th Amendment, we select them by popular vote. So that the principles now are equal between the House and the Senate in this regard. But in the original Constitution, it's popular sovereignty in the U.S. House, a direct vote for the House of Representatives, and then the state legislature selecting the senators. Now, to quickly go through those last 2 provisions of the structural Constitution, Article 1, Section 4 says 2 things. It says that the time, place, and manner of elections are going to be set by the states, but those rules will be subject to regulation by Congress. And so if we're trying to pick out the big idea there, it's that the states are going to have primary responsibility over the rules for voting and elections. The Congress can step in and regulate those rules, but primarily it's going to be a question for the states. So it's the original Constitution sort of embodying this principle of federalism, this idea of state power, and putting primary responsibility over elections and voting in the hands of the states. And then that final provision in the structural Constitution, Article 2, Section 1, is where we get the rules for selecting a president. And so we've discussed this in previous weeks. This is the Electoral College is how we select the president. If you want to know more than you could ever possibly want about the Electoral College, please go back to those lectures. But I'll pause right here, Kerry. That's the structural Constitution. But the big idea, I don't want to lose it. I want to telegraph the big idea here with the original Constitution. And that's that the original Constitution largely left the issues of voting and elections to the states. So again, it's a federalism story, it's a state power story, and it's already setting up that debate that's going to go from the founding all the way through to COVID, which is this question of who has responsibility when it comes to voting and elections, what powers go to the national government, and what powers go to the states. The original Constitution is really, really balanced toward the power of the states.
Got it. So we've got our founding in that original or structural Constitution. And then we have, and you nodded to the 17th Amendment, so everybody remember that in a minute. But you lay out a lot of these amendments after this, so that foundation in the original Constitution of how a president is elected, how senators are elected, how the House is elected, and then really saying, okay, states take it from here, and you figure out who gets to vote and exactly how the time, place, manner around it. So there's some kind of rules and guidelines from the constitutional level, and then the states' rights. Again, federalism, we talk about it every week and dive into it. So I thought what would be really fun is do a little kind of pop quiz, and one that you will not be graded for, people, but let's see where you know about the amendments. So I'm going to give you guys a poll really quickly. So it's the which amendment is it poll. So here I'm going to launch it. If you can't see the poll, don't stress. I will read it out loud to you and you can answer it in the chat. If you can see the poll, go nuts and have fun and start answering it. So here we go. Let's begin with this one. I think I made it harder for the older kids. I realized there's more answers. So number one, this amendment was ratified in 1870 and says that the right to vote cannot be denied based on race. So this bans racial discrimination in voting. Which amendment is it? Is it the 13th Amendment, the 14th Amendment, or the 15th Amendment? So answer in the chat now if you can't see the poll, but which amendment ratified in 1870 says that you cannot be denied the vote based on race? 13th Amendment, 14th Amendment, or 15th Amendment? Okay, next question. This amendment ratified in 1920 grants women the right to vote. So 1920, people, only 100 years ago, women got the right to vote nationally. Was it the 12th Amendment, the 17th Amendment, or the 19th Amendment? And again, if you can't see the poll, you can answer it in the chat. We love to see it there too. And then the final question. Final question is, this amendment ratified in 1965 ends poll tax in national elections. Which amendment is it? This is a hard one. Is it the 24th Amendment or the 26th Amendment? So go through, kind of look. And then I see a good question coming in about a Shelby case. We'll get to that, Karen. I love it. But think about your final answers. And let's Tom do a fact check for us. Okay, Tom, here we go with these. Let's go through this. So Tom, the first amendment, this amendment ratified in 1870 says the right to vote cannot be denied based on race. Which amendment is it?
The 15th Amendment. It's the third of those transformational Reconstruction Amendments that we ratified after the Civil War.
So can you go over 13, 14, and 15 real quick, what they are?
I will always be happy to do that.
Okay.
The 13th Amendment abolished slavery. The 14th Amendment wrote the Declaration of Independence's promise of freedom and equality into the Constitution, and the 15th Amendment promised to ban racial discrimination in voting. Scholars often refer to this as America's second founding.
Awesome. Okay, next question. This amendment ratified in 1920 gave women the right to vote. Which amendment is it?
It is the 19th Amendment.
19th Amendment, so 83% of you got that one right. But the other options are the 12th and the 17th. So real quick, can you tell us what the 12th Amendment did and what the 17th Amendment did?
Sure, the 12th Amendment ends up amending the Electoral College in ways you can refer to in one of our previous videos. It basically is a response to the election of 1800. But that's the 12th Amendment. And then the 17th Amendment provided for the popular election of senators. So I referred to that at the beginning. And then the 19th ended gender discrimination in voting.
Cool. And then the last question is, this amendment ratified in 1965 ends poll tax in national elections. Which amendment is it? The 24th or the 26th?
It is the 24th Amendment.
Awesome. And I'm going to end the poll and show it, but just remember, it's going to show you what people voted for, which the majority ones are correct. I always don't love that it shows you what they voted for and not the right answer too. What is the 26th Amendment?
So the 26th Amendment is promising the right to vote for those 18 and older. And I always like to remind people, because we don't talk a lot about this amendment, but before the 26th Amendment was ratified, many states limited voting to those 21 and older. And so with the 26th Amendment, the American people, it was during the Vietnam War. And so the American people saw soldiers fighting and dying in Vietnam and saying, if you're old enough to serve, if you're an 18-year-old and can serve in Vietnam, you ought to be able to vote in the United States. And so as we see, Kerry, this theme exists throughout American constitutional history. It's part of how African Americans won the right to vote. Women's support for World War I also helped play a role in securing the right to vote in the 19th Amendment. So we see that again with the 26th.
Fascinating. Now, when I think about voting and I think about like the the 15th Amendment, the 19th Amendment, and then the 26th Amendment, I'm always looking at the change in voting over time with these big amendments, but we kind of have an ebb and flow of who can vote in America over time. So I want students to pay attention to that as we talk through and kind of see how it's not always just like a curve up, that it's yes, they can vote, no, they can vote, and why? What was going on in that time period, and why did people's right to vote either get expanded or retracted? But can you give us like a framing in like the pre-revolutionary colonial period up until like 1790s, what voting was like statewide?
Absolutely. So yeah, let's start right there. Let's go to, we declare independence, we have state constitutions, and the states then are, they are tasked with the responsibility of determining who's going to vote. And so if we're looking at that period, again, sort of, the 1770s, 1780s, 1790s, there are two things that you really see, and you want to keep both of these in mind. One is that in the vast, vast majority of states, the rule is that voting is going to be restricted to white male property holders. So that's what you would see as the majority rule in the states. That's what most states are doing. But you even see in this period some variation across states. So, one of the key principles here for the founding generation was a link between the responsibility and independence that comes from owning land, from owning property, and sort of the trust in them to have responsibility to vote. But we already see some states moving away from property requirements. So states like Pennsylvania, like Vermont, are saying that even if you don't own property, you can still vote. Furthermore, we also see some states that allow both African Americans and women to vote during this period. So in my home state of New Jersey, women property holders are able to vote all the way through 1807. At that point, the state legislature said, that might be a little too crazy, we're going to get rid of that. And so women would then again have to fight, once again, everywhere in the United States for the right to vote. But you see it in New Jersey in that period, some women being able to vote. And then you see some states also that permit African Americans to vote, again, mostly in the northeastern United States. But the two big things to take with you are, one, that the founding generation is largely limiting voting to white male property holders, and two, there is some variation in some states allowing some women and some African Americans to vote.
Got it. So white male property owners. So we're talking about typically white male people of wealth, because that property, like I always like to change that back and forth, because back then that's how they're seeing it. Today, we wouldn't think property as directly connected to wealth, but it was back then. Things start to change with this guy right here, with Andrew Jackson. What starts to happen for people's ability to vote during this time period? What time period are we talking about? And guys, if you can guess in the chat what number president he is, you get extra credit. Just that I dole it out like I have some authority, but still.
Yeah, sure. So, before we get to Jackson, just to pause quickly at the Constitution one more time, it is worth, remembering that the Constitution itself, it sets up some of the structures about elections and voting, some structures, some general rules, but there is no constitutional right to vote, and there is no right to vote in the Constitution. There's no right to vote in the Bill of Rights, and that for the founding generation, they just simply didn't see voting as a natural right. They didn't see it quite as fundamental and so fundamental to the American idea as we do today. And so that's precisely why they were okay with leaving it to the primary responsibility of the states to decide who's going to vote and when. So I just wanted to frame that as just a quick reminder of sort of both what's in the Constitution, but also what's not in the Constitution.
And I think that's really important. And Tom, is it right to say that the founding generation writing the Constitution is more concerned about representation than voting?
Yeah, I think that's what you see in Article 1, Section 2, and Section 3. I'd say it's the idea of representation, and then also this idea of balancing the national power versus the responsibility of the states, that federalism would be representation and federalism, I would say.
So now things start to change with this guy. So some of you are guessing in there. Whoop, I just totally blanked you out. And I'm going to give it one more second for you guys to guess what number president he is. But Andrew Jackson, tell us a little bit about Andrew Jackson.
Sure. So importantly, we're fast forwarding here to the 1820s and 1830s, and we see really a lot of changes to American democracy during this period. And I would say it happens sort of at two levels. And so at the first level, what we end up seeing is a move towards universal white male suffrage. And so what this means is, whereas the founding generation had these requirements of property in order to vote, We see states getting rid of property requirements broadly across the United States. And so what does this mean? It means that if you're a poor white man, you're now able to vote all the way across the United States. That wasn't true with the founding. Poor white men were just as, they couldn't vote. But now with the Jacksonian Revolution, poor white men are brought into American voting rights. And so that's one level of Jacksonian democracy, universal white male suffrage. The other, though, is, and this goes back to the zigzag that you were talking about at the beginning, Kerry, which is, for universal white male suffrage, that's happening. But at the same time, we see restrictions for many other groups, including women and African Americans. We see restrictions for African Americans and immigrants becoming more prevalent during this period. And so, as we're on the cusp of the Civil War in 1855, there are only 5 states in the United States that allow African Americans to vote: Maine, Massachusetts, New Hampshire, Rhode Island, and Vermont. And so we see African American voting rights in the northeastern United States, but not elsewhere. That's to say, it's not as though it's nowhere. It is actually in some places, but it's not in a lot of the rest of the United States. And then right here, I see Elizabeth Cady Stanton and Lucretia Mott on the screen. So this raises the question of, what about women? What's the story of women during this period? And here we're going to go to 1848, to the famous Seneca Falls Convention in upstate New York. It's Elizabeth Cady Stanton and Lucretia Mott bringing in supporters of women's rights, both men and women, to come together in Seneca Falls to begin to think about what's our agenda for the decades ahead. Because we as women, we don't have the same property rights as men. We can't sue people or be sued in court. We can't contract, and importantly, we can't vote. And so what is it that we want to advance in the decades ahead? And it's up to Elizabeth Cady Stanton to put down this initial draft of what's our statement of principles. And it's this Declaration of Sentiments, which comes out of the Seneca Falls Convention, written by Elizabeth Cady Stanton. It's an extraordinary document. Stanton takes the Declaration of Independence and effectively rewrites it in a way that's consistent with this push growing out of Seneca Falls towards women's equality. Here is this amazing quote from the Declaration of Sentiments: "We hold these truths to be self-evident, that all men and women are created equal." And here it's Stanton and her allies laying claim to the American Revolution, laying claim to the American founding, and looking back and saying that those principles ought to guide what we do moving forward, that those principles of equality ought to apply to women going forward. And then for Stanton, she's one of the main advocates at Seneca Falls, saying this has to include the vote. This was controversial even among people who were at Seneca Falls. People might support property rights, but some of them thought, ooh, that sounds a little radical, having women to vote. But the Seneca Falls Convention endorses this. And within this Declaration of Sentiments, we see 12 demands from the convention delegates. They include equal education, equal pay, property rights, and then, quote unquote, the sacred right to the elective franchise. And so it's this amazing moment where we're kicking off. Remember, Seneca Falls, 1848, 19th Amendment, 1920. We're talking about another 70 plus years of fighting and advocacy for the women's right to vote. But we see at Seneca Falls the seeds of it. And Elizabeth Cady Stanton and Lucretia Mott would continue to be key figures in the fight throughout that period, and would have many allies, both men and women, African Americans, white. And we see, especially among suffragists, a unification within the reform movement of those fighting to end slavery and those pushing for the women's right to vote all the way up into the Civil War. The last thing we'll say before we get to the Civil War and Reconstruction, Kerry, is in 1857, we also get the Dred Scott decision. And so this is right before the Civil War. This is Roger Brooke Tawney, his court. And we see here the pictures of Dred and Harriet Scott. The Constitution Center, we actually have the Scott's petition. And because what's happening in the Dred Scott case, these are enslaved people petitioning for their freedom. They're going to court and saying, we've actually been brought into free states and we are free people. And so Dred and Harriet Scott are examples of many African Americans during this period laying claim to their own freedom. What does the Supreme Court say? Well, in a divided ruling, the Supreme Court says African Americans are not United States citizens. And as Roger Brooke Tawney, the Chief Justice, says infamously, African Americans have, quote, no rights which the white man is bound to respect. And so it's a chilling statement of what the court decides in Dred Scott at that moment. But Tawney is issuing this ruling in the face of two very powerful dissents, one by Justice John McLean and one by Justice Benjamin Curtis. And both of them, it ends up being this really interesting battle over the story we've already been telling today in this class, which is it's a battle over the American history of voting. where Chief Justice Taney is saying, going from the founding to today, we never could have thought that African Americans would be citizens or equal citizens or should be able to vote. And what McLean and Curtis say in dissent is, Chief, that's just not right. It's not right as a matter of history. We had African Americans voting at the founding. We've had African Americans as citizens in voting throughout our entire history. Is it the rule in most states? Of course it's not the rule in most states, but it's a rule in some of them. And it's an important part of the American tradition. And you need to answer that, and you have not. And so I'll sort of pause there. That's Dred Scott. And that, again, that's, just a few years before the outbreak of the Civil War.
And the reason why we think this is such an important story, and I mean, it is a huge story. It changes in so many ways. But when we bring it into voting, we have to remember when this case comes to the courts and Harriet begins this case, she's the first to say, I'm going to bring this case. And then her husband comes with her and they put his name first because he's a male, but they're fighting for their freedom. They're fighting for citizenship. And as they remove citizenship, as Taney removes citizenship in this case from African Americans, it removes those New England states' ability to give African Americans the right to vote. So we're looking at this as a horrible ripple effect that happens with this decision and removes so many rights, because with citizenship, there's all these other rights associated with it. So you're going to hear this case in this class. We're going to talk about it in multiple classes in November, but this is a key case. And, and when we look at this court case, we look at the horrible decision made by the Supreme Court, and we look at the whole history and try to understand around it. But we bring it up for that reason. And then at the end of the Civil War, wrapping up the Civil War, we get 3 major amendments that affect people's rights and affect voting rights, cannot be denied based on race. So Tom, walk us through these 3 real quick, and we're going to jump into some major voting from African American men and when that started.
Sure. So this is what we've already talked about at the beginning of class today. This is America's second founding. This is this moment after the Civil War where the victorious Reconstruction Republicans are coming back together and saying, we just fought a bloody war. What was it about? And so they write into the Constitution the 13th, 14th, and 15th Amendments. The 13th Amendment abolishes slavery. The 14th promises freedom and equality. The 15th bans racial discrimination in voting. And even just looking back to what we just talked about, Dred Scott, what the Reconstruction Republicans, again, the party of Lincoln, the party of Union, are saying is, no, Chief Justice Taney, you got it wrong. You got it wrong the day Dred Scott was decided. And we're going to make sure you never get it wrong again because we're going to write these promises into the Constitution. And so it becomes a new constitutional baseline for America. And we'll pause, because this is a Voting Rights in America story, on the 15th Amendment. So that promise of ending racial discrimination in voting. And so it comes at the end. So we've already had the 13th, we've already had the 14th, but Reconstruction Republicans and, many, both white and African American, are saying, what we really need to do now is we need to make sure that we promise the political rights of African American men down south. And so with the 15th Amendment, we write that into the Constitution. The Reconstruction Republicans in Congress, as they're putting together this provision, are debating how broad it should be. Should it focus on racial discrimination alone? Should it focus on more things like discrimination based on property, based on education, things like that? So, on the one hand, racial discrimination is a really transformative thing to write into the Constitution, making sure that there's not racial discrimination in voting. But even then, you have more radical voices in Congress, like one of my heroes, Massachusetts Senator Charles Sumner, saying we need to do more than just clearly end racial discrimination. We need to say that we're not going to have discrimination based on property, based on education, based on all of these other things, because the right to vote is so fundamental. And what Senator Sumner and his allies predicted was, if we don't make it super duper clear in the Constitution, when white Southerners come back into power, they're going to find ways around our language, and they're going to deny voting rights to African Americans. And sadly, that's precisely what we see just shortly after this moment. So the 15th Amendment's ratified in 1870. As we get into the decades getting towards 1900, we see white Southerners coming back to political power and using a mix of violence and laws like Jim Crow laws like poll taxes, which require people to pay something in order to vote, literacy tests, which require people to prove that they can read, often having to prove it in the face of white Southerners who don't want African Americans to vote. So they're not applied fairly either. But we see African Americans being denied the vote at the ballot box. The last thing, I don't want to end on that note, but I do want to remind you that with with the Reconstruction Amendments, with the 15th Amendment, we see things that we would have thought absolutely impossible before the Civil War. It's unthinkable that we would write into the Constitution just a decade later the promise of ending racial discrimination in voting. And it's important to remember that for a time it worked. It worked. It was too short a time, but it worked. And we see here this image of African Americans voting in 1867. And it's a reminder that even before we ratify the 15th Amendment in 1870, we have, under laws passed by Congress, African Americans voting in the South, voting for President Grant, voting to ratify the 14th Amendment, voting to ratify the 15th Amendment. And then after that, into the 1870s, we see African American governors, US senators, members of the US House of Representatives, state legislators, all the way down to local positions like sheriff and justice of the peace. We see a genuine experiment and an inspiring experiment in interracial democracy. And so while the United States, unfortunately, again, it's the zigzag, turns away from this experiment for far too long, for decades that would require advocacy by the civil rights movement, it's important to remember that, one, we see a shining example of interracial democracy, and two, that generation wrote the promise in the Constitution. It was, as Dr. King would say, a promissory note for future generations to cash, and so they would.
And I think this is what I love about these next two images. And I love when students, take a real close, clear look. Number one, the 1867, you have what is this image of the first vote. And these votes by African-American men change the tides in the presidential election. It's so impressive. Tom, what is the stat on how many African-American men came out and voted for Grant? Was it something crazy like 95% of African-American men who were registered and voted during that election? It's like a ridiculous, whatever the number is, it's a very impressive participation stat. And it's the other thing that's striking is you have good participation from African-Americans until you see the turn against them by white Southerners. But you see these high participation rates, and then with Jim Crow and violence, you see them absolutely, go all the way down just as abruptly later in the century, unfortunately. And then so you look at this, then you look at this next image and you see the poll tax receipt from 1895. So you've got a jump of basically, 20 years, a little under 20 years, where you see this boom, this experiment in interracial democracy, and it's working and it's unbelievable. And then things like Jim Crow laws, the poll taxes, the literacy taxes, pull all of this back. But written in to that 14th Amendment, written into that 15th Amendment is Congress to have more power to act. So Tom, can you tell us a little bit about that enforcement clause in that 15th Amendment? And then it takes us, almost 100 years to actually really dig in and start enforcing the oppression of African-American voters. Absolutely. So I have my pocket Constitution next to me, so I'll quickly read. On my phone. The enforcement clause of the 15th Amendment reads, "The Congress shall have the power to enforce this article by appropriate legislation." And we end up seeing throughout these different voting rights amendments an increase in power for Congress. Now, I don't want to over-exaggerate it. The states still play a huge role in elections and voting. But with the 13th, 14th, 15th, 19th, 26th Amendment, we do see a theme in these amendments in voting of giving Congress more responsibility, more power. It still requires us to ask that federalism question of what to the national government, what to the states, but it puts a little more weight on the scale towards the national government in that context. If we're projecting forward, Kerry, what we end up seeing for far too many decades in the late 1800s and the early 1900s is the Supreme Court not really stepping in to address Jim Crow voting laws in the South. And so we see African Americans being kept from the polls. But over time, again, we see lawyers like Thurgood Marshall. We see advocates, social movement advocates like Dr. King, like John Lewis, et cetera, et cetera. We see a growing civil rights movement pushing for the right to vote throughout this period, because what we have to remember is there may be a zigzag when it comes to voting rights in America, but it is consistent that people who are left out, those dissenters, always see it as a real claim to what it takes to be an equal citizen in the United States. And so we, I'm sorry, Kerry. On that note, I just wanted to, that's a great point about the gentleman behind me, the statue in Philadelphia. Talk about, give the stakes and the loss of life that happens around voting. So when we talk about the Civil Rights Act, we always like to talk about not just the, civil rights movement. We talk about the first civil rights movement and the second civil rights movement. So behind me, Tom, you want to talk a little bit about Octavius Catto? He died in 1871.
Yeah, so this is part of the first Reconstruction or the first civil rights movement, whatever you want to call it. Octavius Catto is an important African American leader in Philadelphia, and like so many, the thing to remember always is, on the one hand, we are fighting over what ends up in the Constitution, so it's that's a legal question, but beneath that is often literal flesh and blood courage, which Octavius Catto, risked his life and then lost his life in the face of a violent backlash against African Americans fighting for the right to vote. And so we see that with Catto in the 1870s, and then you project forward into the mid 1900s, where it's then the civil rights movement marching in Selma on the Edmund Pettus Bridge, fighting for the right to vote, which ends up culminating in the Voting Rights Act of 1965. And so, we don't have enough time to really do justice to the courage that it took to continue to fight in the face of violence and in face of the law and laws and everything else. But the two things I would sort of emphasize here would be, one, that by the time we get into the mid 1900s, we do finally see the Supreme Court beginning to enforce a constitutional right to vote. And so part of this is recognizing that within the 14th and 15th Amendment, Congress has broad power to realize the 14th Amendment's promise of equality and the 15th Amendment's promise to end racial discrimination in voting. And the two of those together recognize a fundamental right to vote. So that's what the Supreme Court, one, recognizing congressional power, but two, saying we, the court, because we have the Constitution, can also enforce these rights ourselves in enforcing the Constitution. So it's a major jurisprudential and legal shift. So a shift on the court and a shift in what Congress can do. But also we see a shift in politics. And so you still need a Congress. If you want new national laws that are going to protect voting rights, you need a Congress willing to do it. And so, spurred again by the civil rights movement, we see eventually the passage of the Voting Rights Act of 1965, which, I always think about it as, it is very hard to overestimate how important this act was. It really was in many ways the act that really writes the promise of the 15th Amendment's, the 15th Amendment promise to end racial discrimination voting, wrote it into the law. It had Congress write it into the law and provide a structure for enforcing it. And so, again, we think about the founding, we think about most of American history. It's a story of the states having a great deal of discretion as to who can vote, who can't vote. And sometimes this works well. When it comes to women's right to vote, we see Western states are the first states that allow women to vote well before the 19th Amendment. And so there we see an example of federalism bubbling up and becoming a new right that's eventually recognized in the Constitution through the 19th Amendment. But the flip side is we see with Jim Crow, if you give the states that want to discriminate against African Americans a lot of power and don't check them, bad things can happen. And it requires the national government to step in and say, no, that isn't how we do it in America. And that's what the Voting Rights Act of 1965 was about. What it does is it really effectively, the technical term is pre-clearance is what it provided for. But all this really means is that if you are a state that has a historical record of discriminating based on race at the ballot box, one, we're going to attack whatever laws you have on the books as they exist. And two, if you want to change your laws, you have to come to us, the national government, and show us what you want to do. And you can't do it until we say yes. And so that's such strong constitutional medicine. It's so different from the founding vision. It's a rebalancing of power between the national government and the states. And in this first wave of cases, the key case is South Carolina versus Kutzenbach, which is shortly after the passage of the Voting Rights Act of 1965. South Carolina comes into the Supreme Court and says, Congress can't do this. We all know that a key foundational principle of American government is federalism. The key part of that is that states can determine who can vote. And how elections are going to work. So this is unconstitutional. And the Supreme Court says, no, South Carolina, you're wrong. What the Voting Rights Act does, it is strong medicine. It is different than how we've typically done things, but it is at the core of what the 14th and 15th Amendment was about. It's at the core of ending I think he said something like invidious evil of Jim Crow laws in the South that are keeping African Americans from the polls. And Chief Justice Earl Warren, who wrote the opinion, said, white Southerners have been doing this since the 15th, or been trying to do it since the 15th Amendment was ratified and succeed for far too long. The Voting Rights Act is simply addressing that. And then to fast forward, someone asked about Shelby County versus Holder at the beginning of the session today. This is a case in 2013, and it's dealing with the constitutionality of the Voting Rights Act as it was reenacted in 2006. And so again, it's that classic question of what to the national government, what to the states. And the challenge is the constitutional challengers come in and say, you know, the Voting Rights Act, the pre-clearance requirement, that national supervision we talked about, what the challengers say is it's relying on old data. The Congress, when they updated the Voting Rights Act, didn't update the data on which states it's covering. So again, the national supervision only applies to states that have a bad track record on voting rights. And what the Supreme Court ends up saying is, challengers, you're right. At the core level, Congress has the power to pass something like the Voting Rights Act to promote racial equality in voting. But what Congress has to do is make sure that it's doing it in a way that's tailored to the conditions that we see on the ground. That if Congress wants to continue to use the strong medicine of something like preclearance, what it has to do is update the formula that's covering who is covered covered under this preclearance requirement of national supervision. The Congress is using a formula from 1970. It can enact a new version of the Voting Rights Act with an updated formula, but it can't use the old formula. What we see is the court dividing 5-4 on this question, with a vigorous dissent by the late Justice Ruth Bader Ginsburg. What does Justice Ginsburg say? She's joined by her 3 progressive colleagues on the court. What does she say? She says, 1, we've already decided this in Kutzenbach. Chief Justice Warren had it right. The Voting Rights Act it was constitutional then, it's constitutional now. 2, the Voting Rights Act is consistent with the 15th Amendment's text and history. Congress wanted to make sure that we could promote racial equality in voting, both in the courts and through new laws passed by Congress. So therefore, the Voting Rights Act is reauthorized, is constitutional. And 3, the Voting Rights Act has worked. It's worked over time, and we ought to allow it to continue to work, especially when reauthorization was passed by vast bipartisan support in Congress and signed by President George W. Bush. And then I'll let you read the Justice Ginsburg quote on the screen, which many people sort of pulled out in that in the news write-ups after the decision came down. But I think the fundamental thing to remember from a constitutional perspective is that Shelby County is raising the same sorts of questions we've seen from the founding to today. It's these questions of federalism, state power versus national power. And when it comes to voting, what is the role of the national government and what is the role of the states? And I'll just end, Kerry, because we promised to get all the way to COVID, with saying that these are these sorts of questions you're going to see, you already see in the news, and you're going to continue to see a series of constitutional challenges to state election laws in light of the pandemic conditions that we see because of COVID. And these still come down to those the basic question is, how do we balance the state's authority to pass laws in elections and to have clear laws that are guiding our elections before Election Day versus the constitutional promise of a right to vote, and what that might demand of laws that infringe upon that right in certain ways. And so it's important. And the last thing I'll say, Kerry, is these constitutional challenges happen before every election. So people will always raise these questions, but they're all the more vexing because of the challenges of trying to hold an election during a pandemic.
So everybody, you're going to be in the middle of history with this election moving up to it, and things are going to be happening in the next 2 weeks. So think about these founding stories from the constitutional period to the Reconstruction period to the 1965, and think about how you would apply these big constitutional questions and how you would answer them. So this is a great moment in time to be learning about the Constitution, to be talking about it at the table, but watching what's going on with the election. Because like Tom said, there are going to be cases coming in and there are going to be changes coming in very close to the election. And how are the courts going to rule on them? So what a great time to stay tuned. Thank you so much, Tom, for class. We have a great guest on Friday of this week, and we hope to see you all in class this week and next, where we look at battles between the branches and the separation of powers. So what a fun month we have going on here leading up to the election. Thank you all very much. We will hold after class for any questions, and I know Colin has a really good one we're going to get to. So let me pause the recording, and everybody who can stay, please stay.